On December 7th, 1941, Franklin Delano Roosevelt said that day, because of the unprovoked surprise attack of Japan upon the United States, as a day that will live in infamy. On that day, some 2,403 people lost their lives. On September 11th, 2011, another 2,763 innocents died on another day of infamy when those jets crashed into the towers in New York. And so that too is another day of infamy. But on January 22nd, 1973, a decision was set in place that truly is a date that will live in infamy, where, and actually the January 22nd, 1973, date that will live in infamy, where since that date until now, an estimated 60 to 62 million lives have ended deliberately and intentionally under the guise of abortion rights founded upon a court decision made up on a so-called right called privacy. On January 22nd, 2021, was our 48th anniversary of this infamous Supreme Court hearing and decision, and we have lived with those deaths since then. But on December 1 of this year, just this last week, the court opened hearings on what can only be seen, I believe, as historic, as it heard the oral arguments in the most important case in a generation. A case that genuinely presents a direct threat to Roe versus Wade decision as a precedent that was handed down in 1973. Now, on that date in December 1, up till that point, a number of documents were submitted to the Supreme Court in writing on both the opposition and pro side of those debates, of that debate. But on December 1, it was a historic day. Finally, we heard the truth in the opening statements of that particular hearing. And it became a direct frontal challenge to the Supreme Court precedent and precedent upon precedent that has led to the death of multiple millions of babies. And this legal journey started with a lawsuit, as I mentioned. I actually haven't mentioned that is called Dobbs versus Jackson Women's Health Organization. And this took place because the state of Kentucky passed a new law restricting abortions to within 15 weeks of conception. And thus it set up a direct contradiction to Roe versus Wade. And you're going to hear, and you may have already heard, well, what is being debated here, is it going to be 24 weeks, or is it going to, which is the standard, or is it going to be 15 weeks? And it's all an argument about viability. The problem with that is this particular law that was brought into the case was brought specifically knowing that it would probably be challenged and go to the Supreme Court. And because of that, the goal was not to determine viability. The goal really here was to determine whether Roe versus Wade was a correct constitutional decision in the first place. And we know this from the opening statement by Solicitor General Scott G. Stewart of Mississippi. And I want to read this opening statement to you because I think it's profound. And then I'm going to break it up and make comments about it. Mr. Chief Justice, and may it please the court, Roe versus Wade and Planned Parenthood versus Casey, that was another Supreme Court decision that took place in 1992. They have no basis in the Constitution. They have no home in our history or traditions. They've damaged the democratic process. They've poisoned the law. They've choked off compromise. For 50 years, they have kept the court at the center of a political battle that it can never resolve. And 50 years on, they stand alone. Nowhere else does this court recognize a right to end human life. Wow. So it's very clear now that the argument that has been argued, and there was 2.5 hours of oral argument that took place after that, was really over, does Roe versus Wade stand? Is it constitutional? Or did the court aggregate to itself a new right that's not found anywhere in the Constitution? So for 2 hours or 2.5 hours, the oral argument continued. So December 1, history was made by Scott Stewart. He went directly, in this statement that I just read to you, he went directly to the core issue. As so long as Roe stands, so long as the 1992 decision in Planned Parenthood versus Casey stands, our country is haunted, was the word he used, by the fact that the unborn human life is simply considered insignificant, not worthy of constitutional protection. The bottom line is that neither decision have a basis in the Constitution. That's his argument. Nor can these decisions find home, as he states, in our history or legal traditions claiming a so-called right to privacy. Before 1966, there was nobody even on the left that was arguing for abortion rights. And most states had laws banning abortion. These decisions damaged the democratic process, Scott goes on to say, and poisoned the law with the argument of precedent upon precedent, and therefore should end the discussion of this issue. And that became the argument by one of the justices, where he said, well, the precedent has been set. And the idea is once a precedent has been set, it can't be overturned. Then my question is, what do you do with Dred Scott? It was overturned by the 13th Amendment regarding abolition and the 14th Amendment regarding citizenship to all, regardless of race. Or the issue of the reversal of the horrifying decision on race and in the decision of Plessy versus Ferguson. That was reversed in the Brown decision, where they said they were separate but equal. Horrible decision, and was corrected. So just because something is precedent doesn't mean it stays there forever. The bottom line is the court can make mistakes and has made mistakes in the past. And in my opinion, clearly made a mistake in Roe versus Wade. In the end, the issue is not resolved. Listen to Justice Sotomayor on this one. This is interesting what she has to say. The issue of when life begins has been hotly debated by philosophers ever since the beginning of time. That not, by the way, really clear as or true at all. It's still debated in religions. So when you say that it is the only right that takes away from the state the ability to protect life, that's a religious view, isn't it? Boy, she sure shouldn't have said that. What she is saying then is that the court has decided on a religious issue. Roe versus Wade then was decided based on a religious issue. Especially since we can't determine when life begins. It's supposedly hotly debated. But apparently she feels the court has settled the question. Just exactly how is that possible? Doesn't seem settled to me. We're still debating it. Nor can the issue of abortion be solved by the court, as the Constitution is silent, and it's also just morally indefensible. In this case that has come up before the Supreme Court, the state of Mississippi, through the Solicitor General, said to the Supreme Court, the only thing you can do in terms of reason and the text to the Constitution and the overreaching tradition and respect of this court is to back out of the question and leave it to the people. It was argued at the end of this quote that I gave you earlier, for 50 years, they have kept the court at the center of a political battle that can never be resolved. And 50 years on, it stands alone. When the oral arguments continued that day, those who were supporting abortion rights only had two arguments. The first argument, which I just mentioned, was precedent. The precedent is already there. We've got 50 years now, or 48 years of precedent, and it was reaffirmed in 1992. But as I've already mentioned, there have been a number of other Supreme Court decisions that were either overturned by constitutional amendments or by the court itself. The second argument that was used on that day, on December 1, was that it would be a step backwards. And the editorial board of the Los Angeles Times, I think, probably expresses this idea better than I have heard it anywhere else. In anticipation of the oral arguments, Los Angeles Times wrote, access to abortion has been hobbled even under Roe. But then it goes on to say, but a swath of states banning it outright is a step back from modernity that frankly a decade ago would have seemed unthinkable. And so the argument goes is that, well, maybe it is a wrong decision, but we've had it now for these 48 years, and to overturn it would be a step back for women's right to an abortion and would cause nothing but chaos in our society. It's kind of an interesting argument. So in other words, we're going to leave the decision standing simply because it's uncomfortable, simply because society will have to make some changes. You mean we might have to rethink our sexual habits and how we approach society and what we think of human life? But I really think Scott Stewart hit it on the head when he said this at the end. Nowhere else does the court recognize a right to end human life. Wow. What a statement. John 10:10 says this. The thief comes except to steal and to kill and to destroy. And I have come that you may have life and that you may have it more abundantly. Now, before you argue, well, Pastor Mike, that's talking about the gospel. Point well taken. Here's the issue. The gospel is completely incompatible with abortion rights. It is pro-death. It is for the murder of the innocent. The gospel, on the other hand, takes those who are dead and makes them alive. Important distinction. Sotomayor also argued that we can't really know if a child really feels pain or not. And then she compared it to a person that was brain dead. Justice Sotomayor, just so that you know, a person who's brain dead is dead. A baby in the womb is alive. It's just that simple. And so the gospel speaks directly to life, from death to life, and is completely, therefore, incompatible with abortion rights. And secondly, the incarnation. The incarnation of Jesus Christ also stands as a picture of what life is all about.